audio.
Call to order the, whatever date it is today, Board of Appeals meeting, October 22nd. First items of business, agenda adoption of the March 22nd, 2018 and July 9th, 2018 meetings minutes.
Motion to approve is written. Second.
All in favor? All
Aye.
opposed? Business done. New business, public hearing request of Judith Blood, appealing the issuance of a permit to Weber Oil and Weber Development Corporation to demolish the old Taconic, is that how you say that? Taconic? Ellsworth Community Center building located 10 Bangor Road. Who's here for Weber Oil? Anybody? Nobody's here? We do our best work unopposed. All right, here's what I have for a record. I have a permit issued by the City of Ellsworth, dated 9/10/18, signature approved, with a package that contains CES, asbestos, etc., etc., etc. That'll be marked or whatever. I have a letter from the Ellsworth Historical Society dated 9/13/18 that was part of the record. I have a quitclaim deed from the City of Ellsworth recorded in 2006 with the subject property. I have a record from 6/6/05 from the City of Ellsworth concerning the transfer. Anything else that I need in the record? And I also have your, is Ms. Blood here? Hello. We have your appeal, okay? Now, the first thing I want to remind everybody, anybody have a cell phone? Hold it up, turn it off. Please, nothing is more annoying than the cell phones going off. I go to court all the time and judges beat me for that. Bruce the bouncer here will take care of it and it will go off. Second thing is, we're here not because of any personal stake in this particular application or what Weber did or didn't do. We're here because the Board of Appeals has jurisdiction to hear certain things. And we've invited our attorney, Ed Beara, to guide us on whether, first question is, can we even decide this thing? Personally, we might agree with you. Personally, we might support you. But the question we have on this board is, do we have jurisdiction to hear your request to stop the demolition of this particular property? And the question is, did the city act within its jurisdiction in issuing that permit? We are all well aware that the Weber Oil Company's bidding process, we're aware from what you put in your application, what they told the city. We're aware what the city wanted. We're aware what was the image created, but we're also aware of what the deed says. And that may pose a problem for you. And I'm alerting you to this because the discussion is going to be focused on that, because the city granted a deed with no restrictions. And if anybody needs to see the deed, I have it here, and you're more than welcome to review it. And I'll read it to you, just in case. It says the city body corporate grants, and then there's a description of the property. It goes down through numbers, meets, and that word thence, which I hate. Thence.
Best word in the world.
Come
on,
that's why I don't do real estate. Thence, reference to magnets. The above described premises conveyed subject to the right for all purposes granted to Springer Realty, meaning intending to convey the premises. There are no promises, there are no restrictions, there are no, you have to keep the property alive, you have to restore it. There's none of that in the deed. So if there are questions about that, you can ask our attorney or the city who represents us and you what that means. So, without further ado, Ms. Blood, are you here by yourself or do you have other people you want to talk?
There may be other people who would like to speak as well.
Okay, what I'm going to do is everyone can talk. We'll give you all the opportunity. When you come to the podium, we're recording you. And so if you stand up there and don't state your name, we won't know who you are. We may know who you are, like Rebecca back there. I've known her for quite some time. I know who she is, but anybody reading a transcript later down the road, if there is one, won't know who you are. So when you come up here, please state your name. I don't need to know where you live. Just say your name and then stay what you want. You can talk about pretty much everything, but if you start going too long, I might cut you off. So Ms. Blood, I'd like you to come first. Tell me what you want us to do and why. We would need to make a record. So without further ado, I introduce you.
Good evening. My name is Judy Blood. I live in Ellsworth Falls. I stand before you this evening representing citizens of Ellsworth Falls and some citizens of the greater Ellsworth area. On September 10th, 2018, an application for a permit to demolish the Ellsworth Falls Community Building was filed by a representative from Weber Development, Weber Energy Gas, and approved by Dwight Tilton, Code Enforcement Officer for the City of Ellsworth. That permit should not have been approved. The issuance of the permit is in direct conflict with the agreement of Weber Energy Gasoline and the City of Ellsworth. This is a long story, a story steeped in history between two major characters, Weber Energy and Gas, now Weber Development Corporation, and the Ellsworth City Council. In order to understand the relationship, we must go back to the late 1980s. In 1986, according to Ellsworth City Council meeting minutes, an offer of $20,000 was received from the Weber Oil Company to purchase the Ellsworth Falls Community House. They would demolish the building and update their Exxon station on the adjoining lot. The city manager had been advised that their offer was approximately 50% of the true market value, and for that reason, as well as community sentiment, he recommended that the council reject the offer. On motion by Sprang, seconded by McCormick, it was unanimously resolved to reject the offer from Exxon Corporation to purchase and demolish
What date was that?
the Ellsworth Falls Community House. I have the minutes, so they should be in your packet.
You
I
said
can get you a
1986.
second copy.
You said 1986.
1986, but I don't know the exact date.
We have from '05. Do we have 86?
Yeah,
Is it in there?
It should
December
be.
15th, 1986.
Clearly, in 1986, the Ellsworth City Council began their 30-year shepherding of the community
Oh,
house.
here, I get it.
I refer now to the Ellsworth City Council meeting on September of 1989. At this meeting, quote, Exxon has made a proposal to the city that they are willing to provide the funding to move the Ellsworth Falls Community House back approximately 15 feet onto a foundation. This would provide a better sight distance for the mini-mart, their mini-mart, located in that vicinity. As recorded in the minutes from that meeting, quote, since this is a historical building, Lawrence King, chairman of the Historical Preservation Commission, has been contacted by Exxon officials with regards to moving the building. Mr. King has volunteered to handle the bidding process as chairman of the Historic Preservation Commission. End quote. It was then unanimously resolved to authorize the city manager to negotiate an agreement with Exxon or Weber Corporation regarding the Ellsworth Falls Community House. Again, the value of this historic building to the community of Ellsworth Falls was protected by our city council. This sets the stage for the city's request for proposals dated January 2005. The community house was put out to bid by the city of Ellsworth. In its RFP, the city council noted, quote, the city of Ellsworth is seeking proposals from parties interested in the purchase of the following historic properties. In the description of the Ellsworth Falls building, the RFP stated, quote, this structure is not designated as a local historic landmark, but is considered to have significant local historic interest by the Ellsworth Historic Preservation Commission, end quote. In its selection criteria for the RFP, the city wrote, the city will accept the proposal that is considered to be in the best interest of the city. Further, in the proposal requirements, the city penned, quote, any future change in use at any time will require the approval of the city council. In their successful 1.5 page proposal dated April 1st, 2005, Weber offered the city $5,000 for the building and land. Curiously, this was $15,000 less than the 1986 offer rejected by the city more than 20 years earlier. One can assume the council approved the proposal because Weber assured that they would immediately implement the correction of items mentioned in the city's loss consultant's report. A report which outlined the building's needs as such. Quote, "The building has been allowed to degrade to the point of being a hazard. There are rotted windowsills, rotted stairs, mold from roof leaks, and overall poor condition." Weber's proposal assured the city, quote, "The applicant is ready to fund the requirements outlined in the May 2004 report from the city's loss control consultant." And further, the financial strength of Weber Oil Company is well known. In addition, the applicant has sufficient land to move the building onto an alternate site. I end the quote. And further in their proposal, Weber included, quote, "We are not purchasing this property for any grand development scheme." Interesting, the sign on the property now reads, "For lease, we'll build to suit." The city council, I am certain, felt secure selling the property for $5,000, knowing that Weber understood the importance and the expense of maintaining this building, and assured the city that they would. The history of the city council's shepherding of this building is very clear. From the late 80s, with its refusal to allow Weber to buy and demolish the building for their own betterment, to the sale of the building for $5,000 in 2005, with the understanding it would be taken care of. Why else would an offer of $5,000 have been accepted? No wonder the inclusion of number 4 in proposal requirements in the City of Ellsworth's request for proposal. Any future change in use at any time will require the approval of the City Council. Certainly, demolishing the building constitutes a change in use. The City Council acted in good faith for the citizens of Ellsworth. They understood the importance of this building to the history of the village of Ellsworth Falls. In requiring the approval from the council for any change in use at any time, they assured the citizens the sanctity of this building would be protected. Therefore, my appeal that Dwight Tilden's issuance of this demolition permit is in direct violation of the City of Ellsworth's RFP. Approval for this particular permit must go before the Ellsworth City Council. I thank you.
So that's your request. You want us to remand this to the city council?
That is my request.
All in favor? I'm serious. All in favor? I think this is their job. I don't think this board's the right one. All in favor of remanding this to the
Just a
city
point of
council?
order, you
Yeah.
brought up the question if this is the appropriate board to hear this. There really hasn't been a determination on that yet. Is that something our attorney could help us with?
I'm more than happy to. I wanted to hear Ms. Blood's presentation, and if you want to hear others as well.
I know what she wants.
I listened carefully. My view is that you're not the proper board to appeal to. You're authorized to hear appeals that arise out of a dispute over valuations when it comes to assessments, and to deal with disputes that arise out of the land use ordinance and other things. But what we've heard from Ms. Blood is that would be an argument that you would make if you were either before the city council or before a court trying to say that this is how this should be interpreted.
That is correct, but I was told that this was my only option.
I don't know who told you that, but I would advise this board that what you have presented is not something that this board could deal with. Mr. Toothaker only partly in jest said maybe we should remand this to the council. This board can't remand anything to the council. You can seek redress through the council and see if the council would take any action. You've laid out a case for thinking that the council's actions over the years have been such that it leads to the conclusion that it must have intended that this building be preserved. I wouldn't say whether that is or isn't a winning argument. There's certainly a lot of case law that says that when you have an agreement to buy or sell property and then the deed is prepared and the buyer accepts the deed from the seller, that whatever was agreed to before is merged into the deed, which is why I think Mr. Toothaker read from the deed before you made your presentation. You may be absolutely correct with what you're describing. I don't think that this board is in a position to say what the council thought or wanted or intended. But more importantly, it's beyond their jurisdiction because this isn't arising out of the zoning ordinance.
My direction was that I needed to, I have a timeline of my involvement with this process, starting back into.
I'll help you out. We can stay proceedings here, if we all agree, and keep it pending here. I'm not sure that you're gonna make out any better here, and then you can make your presentation to the city council. They may be more sympathetic, given that they entertained all. I see what you're saying. I mean, it was promise after promise after promise, and now let's wreck it and do what we want with it. And the $5,000 is, so what if the property's worth 40, 50? It's the historic value, and I don't think anyone here overlooks that. But I'm gonna get right to the chase. I'm gonna move that we stay proceedings here. You still have an appeal pending. That you have up to 6 months to apply to and take your petition to the city council to see what they have to say about it, the politicians that they are. And Dwight did what Dwight does. He follows the ordinance, he gives them the permit, he creates the controversy, which he usually does.
The reason for my being here
I know why you're here.
is I was told that I had to file an administrative appeal
Well,
for
I
the
don't know-
issuance of the permit.
And what we're doing is we're keeping your option open. But I'm suggesting we take no action here tonight, because if we decide no and kick you out, then you have to appeal.
I'm going
What-
to Superior.
Well, that's wonderful, but I think that your better shot is with the city council, because a breach of contract action has clearly been made out based on representations. Real estate law is weird, that's why I don't do it. And I read you the deed because the deed controls. All the wonderful promises that you keep, well, Ed sort of hinted they all go aside, or sometimes they're included. But if we were just to stay your thing here, in other words, it's still pending, and give you 6 months to go to the city council to seek a better answer than we could give you here tonight, I don't think we're the one that can give you the answer you want. Okay?
Could I offer just a couple of points of
Absolutely.
clarification? First, if you were advised that you should seek an administrative appeal, that would be a reasonable thing for somebody to advise you when you're challenging the code enforcement officer's decision.
Issuance. Mhm.
But the code enforcement officer wasn't acting so much under the zoning ordinance or any ordinance that this board reviews. So there's really not much for you to appeal to. If you looked at your own comments, you never mentioned land use ordinance section, whatever it might be, that we could look at.
No, because I was I was told, although it didn't seem to fit, I was told this was the only option that I had.
And I told her that.
Okay.
Well, she's relied upon the city's agent, so let's give her the second shot at the apple. All in favor?
Second.
It might not be done.
I'm gonna make a motion that we stay the proceedings here. We put this away out 6 months to give her an opportunity. I don't know the city council schedule. They may wanna hold hearings, and we can always bump it out again if we need more time. Yes, sir.
Yes.
The problem creator.
Well, here's my concern. A reason Mrs. Blood and I have been communicating with this for quite a while. And And I told her as soon as I issued the permit, I would call her and tell her. When I issued that permit, I thought, in my mind, just being a code enforcement officer, that she could challenge my decision to, so that's why we're here.
That's why we asked him to come.
Okay. My issue is, right now, I have a permit out there that is active.
Well, can't we issue something that says they can't act on it with the inherent authority granted to us by whoever knows who, whatever? Will they stop doing things at your request? They can go wreck the place.
Right now, they can, they've agreed to wait until the decision.
Ed, what can we do to stop that?
It says here, an appeal to the zoning board of appeals stays all legal proceedings in furtherance of the action. So I don't know if that includes tearing down the building.
Well, I think we can issue a stay on
Stay
the
on the
demolition
building, yeah.
permit. I think we have jurisdiction to do that. And if we don't, somebody can challenge it, go up to the law court and make new law. Take about 2 or 3 years and then get a delightful decision, remand to think it was right, wrong, indifferent. But I'd like this thing heard by the city council. They created the problem, they should fix it.
You raise a very interesting alternative, this idea of a stay, which you would be issuing if you voted to do so, despite really having no jurisdiction over the appeal unless you're relying.
We don't know if we do or not.
Okay,
I'm saying we do, sort of.
all right. As you say, if the board were to vote to do so, then I guess it would be incumbent upon Weber to act in response to that.
Well, they're not here, so.
By either appealing your decision, or going to the council and saying, let's address this situation.
I say we have the authority, inherent or just. So I'm gonna make a motion. I'm gonna make a motion that we stay proceedings for 6 months. I'm gonna make a second motion that we issue a stay on the demolition permit that requires Weber to take no action until this matter has been heard by either the city council or others that can tell us what the action is, and I'm gonna, I think that pretty much covers it. Do I have a second?
You can only have one motion on the floor at a time.
I can have 2. Motion that we stay proceedings for 6 months.
I'd second that.
All in favor? All opposed? I like your dissent. The next thing.
May I ask one question? So let's say that the council acts and says, "Nah, as far as we're concerned, Weber, you can go ahead and tear it down. That's what we intended, or we didn't intend to impose these conditions." And let's say that they do that next month.
Then she can come back here, ask for a hearing on whether we had jurisdiction and whether we can actually finish this and issue orders that stop or whatever. And then if Weber doesn't like what we do or they don't like what we do, they can appeal and have fun in law courts.
So when you said 6 months, you meant 6 months or
Or
until the
sooner.
city council
Well,
acts?
I was thinking we'd set this out 6 months and accelerate it if the city council actually takes an action on this. And we can
That's
be,
understandable.
we could come back earlier. I mean, we meet twice, 3 times a year. We used to meet more, but
Just so that
we
you
trained
know,
late.
I have requested to be on the city council agenda. I was denied that privilege because they said this was a quasi-legal proceeding and that I must come here first.
Well, now
I
you can
think
tell them you
you've done that.
came here, you saw, and that we asked you to go back to them because we think they created the problem in the first place. And then we'll see what happens once they hear from you again. And we'll, if, Ed, you could draft up something that I can sign or Steve can sign, that the city council can see that we did in fact meet, we did in fact take votes, we did in fact make motions 4-1. I was the one last time they were 4. The second thing is I want to put a stay on the demolition permit, that it not be acted upon until reviewed by city council, and then we get back, and then if we, or us afterwards, so that she gets a fair whack at what she's trying to pursue.
Is that the same thing as a rescind the,
No, the permit stands, but they can't use it.
okay.
It's issued, but they can't use it. They can't go out and wreck the place. Now, I don't know how much
Already
legal
begun.
authority that has, to be candid with you. But-
I'll tell you, I don't think it has any legal authority, but I'm not gonna stand between you and your words. If you want to make that a motion, I know better.
Yeah, I make that motion.
If we rescinded it, would it have legal authority?
No.
Neither?
No, because I think the premise here is that you don't have jurisdiction in the first place.
However, I think Weber's
I think,
position in their good faith they might go back and figure this out.
I know that that's inherent in your motion. And
I hope they do.
You've almost convinced me that you have the authority to stay this appeal and urge the city council to take it up.
Tell me where I can't.
Your authority.
No, I don't want to hear it.
Could I have clarification? I really don't understand why this isn't the appropriate board, because in the appeal for administrative review, it clearly says an appeal may be taken to the board by an aggrieved person from any decision of the code enforcement officer as appropriate within 30 days of the date of the decision appealed.
What are you reading from?
I'm reading from the City of Ellsworth Unified Development Ordinance, Chapter 56.
That's right. You're reading from the ordinance and the decision arising out of the ordinance. That's not a decision that has arisen out of the ordinance, that the issuance of the demolition permit isn't by virtue of authority granted the code officer under the Unified Development Ordinance.
So that
And
Mr.
as
Tilton
I
does not
said,
have the authority to give demolition permits? Is that what you're saying?
I'm saying that the authority for that isn't found in the Unified Development Ordinance, and that's what you arguably appealed under, but as I pointed out, I think, and you must agree, you made no argument whatsoever to suggest that the code enforcement officer's decision was at variance with anything in the Unified Development Ordinance. If you have something like that, as opposed...
There's no demolition mentioned anywhere, I don't believe, in any of the ordinances.
I guess the question is, where does Dwight get his
So
authority to do it?
I don't know, does Dwight have the authority to issue a demolition permit then? Because it's nowhere stated in the ordinances?
I would sooner say that no one needs a permit to do that then. Okay?
So, where do we stand on the stay? Motion made.
Conceptually, I'm in favor. I just was checking to see what the appropriate language should be.
If it has no legal effect, it has no legal effect, but I think the...
I'll second Jeff's social statement.
All in favor?
I suppose.
5-0.
Social
Wow.
media.
Wow. Yes.
Steve
I
said it
did
was
have a
social.
question.
Come right up and state your name.
Well, you may not want me to speak because I don't live in Ellsworth. I'm Glenita Thompson, and my question is, if you don't have the legal authority to act on this, can they leave here tonight assured
No,
that it won't happen?
No.
That they can demolish the building?
no, that's the problem.
Is there another way that it could be approached?
We're not here to give legal advice. What I'm here to say is, this board may or may not have jurisdiction. It's leaning, according to our attorney, that we don't. And so, we're not gonna make a decision tonight. We're gonna leave it open. If she wants to revamp her argument and look up the demolition codes and addend after she goes to the city, maybe she'd hit a point, but I don't know. I don't know what Dwight's authority to issue demolition permits. We have a code the city has a code, and people usually, what we're dealing with, land variances, setbacks, and Dwight can't issue those things. We can, if nobody complains too loudly, and generally do. We do tax abatements. If our tax assessor assesses you incorrectly according to you, we can have a hearing and we can either raise it, lower it. We generally never have raised it, but we have lowered a lot of them. And then this thing comes along, and we're asked to go what I think is beyond the scope of what we do here. And I see why she's here. I know why she's here. You all know why she's here. But are we the right people to complain to?
That's my
And-
question.
and then-
Can we be
but what I'm-
creative?
Well, no, I'm saying, let's wait and see what the town does. Your politicians who created this problem in the first place. and you might want to go see a lawyer about which direction you go. I'm not taking away your ability to come and ask us our opinion on this. You may not like it, maybe you will. But I think the town's board, the selectmen are the ones that need to address this. There were promises made, and they're not being kept.
But that doesn't make anybody feel better tonight when they walk
I'm
out
not
the
here to
door.
make you feel better. I'm here to rule on an issue. We've ruled on the issue. I've told you we don't have jurisdiction. I don't know if anything we've done here tonight is going to have any legal authority, but at the same time, it's not going to hurt her case. And hopefully, nobody does anything and you can get before the city council.
Thank you.
Miss Rebecca.
Mr. Tooper, gentlemen, question. This property belonged to the city of Ellsworth, and we know that $5,000 is desperately below the price. So my question is to the city attorney, if an asset that was entrusted through written agreement to an entity is not being used as they agreed to, why can't the city itself and the city's attorney go after that entity? Because basically, what they did was steal it for $5,000. Now they want to destroy it, make it a business enterprise. But they breached their agreement.
Ed, do
So
you want to answer a question, or is this
why-
beyond? Rebecca, please don't take this wrong. This isn't a free legal clinic. And Ed is here to advise us on questions, and I think he's done that. And see, what'll happen is what if, what ifs, what ifs, what ifs, and I know that's what you're all asking. What do we do? The only thing we can tell you is, we've acted, we've made a motion, and we're not going to hear it tonight.
Okay, I appreciate that.
And people in your position might be wise to seek out legal counsel. And that's all we can say. He's here to advise us. This isn't question by question,
Okay.
tell us the law. So, as great a mind as Ed Barra truly is.
So that's not, the
Sorry.
The appeal information that we got from the city says that if you had decided to not go against the demolition permit, then we can go to Superior Court.
But here's reality. A demolition,
Would you I don't mean.
I don't want
That's
to
what I'm trying to
throw you
ask
into
you. That's what I'm trying to ask you.
answer the contestants' legal
Because
questions.
this is in the interest of the city of Ellsworth as well,
Would-
because they could have made a lot of money off that property if that's what they were intending to do. So my question is, if we can't be sure that we can actually stop them, then my question is it not an interest of the city that something that they gave over for preservation is being misused? Because that is an asset, really. A historical building is a city asset. They agreed to do something. I don't understand why that would not be of interest to the legal department, if you will, of the city.
Well, let me offer you just, I'll make some observations and ask you a question when I'm done. I'm looking at the action plan that was prepared by Maine Municipal Association before this property was offered for sale or to bid. And if it was such a valuable historic asset, I'm troubled by the findings of the Maine Municipal Association after it reviewed it, because it lists at least half a dozen or more reasons it's a fire hazard, building degradation, you name it. That all being said, and you've made very credible arguments as to why this property, why the city may have sold it for the price that it did. I'm not suggesting that you're going to be successful or not with those arguments, but if you're not comfortable that this board has done more than it can do for you, then the more definitive thing for this board to do would be to deny your appeal, and that gives you access to the Superior Court if you want to proceed there.
And the question was, is that not something the city would want themselves?
Oh,
I don't really understand
I
the
could-
scope of the legal services for the city of Ellsworth, but,
I wouldn't possibly speak for the city council. I don't have any reason.
so no one directs your activity in that regard? I mean, it's not like the city has a department that looks out for loss of, interests and things. I mean, I don't know how that works.
Well, I could tell you
That's-
that the city council is authorized to, by charter, to sell city property. And it did so in this instance. Whether all of the arguments made by Ms. Blood and that you've alluded to would carry the day and reform the deed from the city to the buyer at that time, I'm not in position to say whether I would know that or not. More importantly, I'm not in a position to know what the city council might do if you were to approach the city council at this point in time. And they would be now the fourth city council, I guess, to have dealt with
Right.
this matter. So I'm not sure what level of interest or what issues they would find germane.
And if they did not support their earlier contention that everything would have to go back through them if there was any change of views, could you speak to what our process for appealing to whom? I mean, could we appeal to the Superior Court if the council doesn't hold up their own decision from 2005?
Well, I'll respond to the question that you didn't ask because I can't accept your premise. Let's assume that the city council, for good reason, denies your request, as opposed to because you think they're failing to uphold something that an earlier council did. For whatever reason, they deny your request. Your question of me, I guess, is do you have an appeal right from the city council's decision?
Yes,
Right.
that's the question.
All right. The answer is yes, but likely a court is not going to find that to be a very valid appeal. The council is the embodiment of the city, and so if the council were to reject your invitation to declare what Weber proposes to do to be some breach of an underlying agreement with the city,
The entire premise
don't
of the
think-
request for proposals,
well,
yes.
And
True.
what
I was
came-
here for all those meetings.
Okay, well, the city council minutes of that meeting make no reference to the request for proposal. They just said, sell the building to Weber. And the deed just says, sell the building to Weber. Okay. Now, it's the council's authority to deal with city property as it deems appropriate. The question I would have regarding an appeal that you might take of the city council decision, if it were that the correct decision has been made and we're not going to look into it further, I would question whether you as a citizen have standing to challenge that. You'd have to have some sort of particularized injury arising out of the council's decision that would make you somehow uniquely situated or different from every other citizen in Ellsworth. I'm not saying this to discourage you from taking any
I'm not
avenues, any
discouraged.
approaches you want, okay? I'm just laying that out there for you, that it might be a steep hill to climb.
Yeah, there are other people in this audience tonight who also sat in audience in 2004 and 2005, who also heard all of that discussion. It's unfortunate if they don't record things as they were discussed in the meeting. I can't, speak to what was omitted from minutes, but I certainly can speak to what I heard in the council chambers during the meetings where that was discussed.
I don't mean to have an ongoing dialogue with you, but I don't think that this board, and I'm certainly not offering my opinion or observations and suggesting that they would be any more valid than yours as to what the city's intentions may or may not have been at that time.
I think the
Those-
RFP does that. It tells us what their intentions were.
I think you can request anything in the world you want in an RFP, ma'am. And when you get one proposal, you then decide whether you're going to accept that proposal and what the terms are going to be. And the record is blank after that. So it's a difficult row for you to hoe. I'm not discouraging you from hoeing it, but I think that it's a difficult row.
Thank you.
So where do we stand?
You've made two motions and they both have passed.
Did we both have passed?
Yep.
Anybody else wish to comment, concerns?
I think that before Ms. Blood speaks, the only thing I offered was that if it's Ms. Blood's appeal, if she thinks the better course of action is to have you deny the appeal, and have a direct appeal to the Superior Court, that would be open to her.
On jurisdiction grounds.
Yeah, and
You want to
if
leave
she,
it open, or you want us to make a decision?
I was not prepared to make this decision this evening, so I would have to take some time to think about this. I have been working on this project since 2015. I have a whole journal of what I have done and to whom I've spoken and what's happened as a result of all of those conversations. I felt as though I was being guided correctly to this direction. I was hopeful that tonight you would agree with my appeal to Dwight's permit. You would then hold that in abeyance until the city council met to hear it, and then we would go forward. That's not at all what's happened, and so I was totally unprepared for this chain of events.
Well, I think
I
we
think
have.
that's exactly what happened.
Exactly what happened.
No,
We're not going
because-
to make a decision
Because
tonight.
right now, I will tell you that Dwight or someone from his office has spoken with Weber, and they have agreed to not tear down the building until today. And so it isn't really what,
So would you like us to make a decision here tonight?
Well, I have a question.
so if I walk out of here tonight, that building could be torn down tomorrow, and there's nothing that I could do about it.
Can I ask her a question then?
Yeah, well,
On this demolition permit, there are 2 buildings.
There are 2 buildings.
And I just want to make sure that you are only appealing the demolition of the 1 building.
That is correct.
Okay, so
the big,
nothing
big red
stopping.
thing to go, right?
So we've already voted for a stay on the whole demolition permit. When in reality, nobody's appealing the demolition of the 2nd building, which is the red building in the back, correct?
That is correct.
I thought we were just talking about the big square one, not the
The permit.
Barney-looking thing.
The application permit doesn't necessarily make that clear. It also says there are 0 stories, but there are 2.5 or more.
So where do we stand?
Should the record be clarified that your motion is applicable to the Taconic, is that what you call it?
Well-
Building only?
Well, that's what they came in here for, just the older, the one historical building. The other one's a barn that's out back, right?
That's what I
Right.
understand.
That is
But if we
correct.
put
You
a
don't
stay
care
on the
about that.
permit,
That's not.
It's not that I don't
They
care
can't
about
tear
it, I'm
down
not
the barn.
arguing that one.
Right.
You don't, all right, so our decision will only apply to the building
Taconic
itself.
building.
Yeah, Taconic.
Does that decision tonight rescind his order, so there is not a valid demolition permit in existence?
Ed?
No.
No.
That's the problem. The question is, do we have jurisdiction to do anything? To order them and that it's enforceable? And, you look through the ordinance, I'm trying to find out where Dwight gets his demolition stuff. This is all new. We've never had an appeal like this.
Well, I just think it should be clear that nobody is wanting the demolition of the red building stopped.
No, I don't think that's even part of it tonight. See, that's the problem here is, we've never had this request before. We've had everything else but, and we're in nebulous territory. And this is our guide, this, city ordinance. I've been looking through it, which is authority to issue demolition, trying to find it.
The only place it's in there, Mr. Chairman, it's in the fee schedule when we have a permit. And actually, the demo permit is under a building permit, and that's the authority we have.
So do we have jurisdiction in it, if it's a building permit?
You do have jurisdiction.
If it's a building permit? Did they
But
ask,
the-
they
the-
just asked to
the-
wreck the place, right?
The-
They didn't file a request to build.
Right, but
They're wrecking.
the demo permit it's the same format. If you look at it, it says building permit, and it's the demo. In our fee schedule, we have a different fee for a demo
The
permit.
demo of a building.
Right.
So if you wanted to frame the issue as one, in order for you to have jurisdiction, the applicant would have to argue that under the zoning ordinance, the code enforcement officer erred in issuing a demolition permit for this property located in Zone U. Is that what it is? Urban. And the appeal isn't premised upon there being anything in the ordinance that the code enforcement officer missed or misinterpreted. The appeal is that the underlying property rights of Weber do not include the ability to remove this property, and we've always, with good reason, I think, taken the position that this board doesn't analyze restrictive covenants and property rights. Either you have standing to appeal a decision to this board or you don't, but we had the case of the, I don't know if it came to this board or the planning board, Belcher or Belch, the covenants on whether it was a residential property or not.
I think it was this board.
And we, that
That makes
Lockwood agreed with us
That's
that
what-
we shouldn't be delving into those things. So when I say you don't have jurisdiction, it's because the appeal itself does not speak to anything within the ordinance that.
It talked about the history of negotiations of the property, which led to a deed being issued that didn't have any restrictions in it. And so we're stuck with the deed, which was why I read it,
Right.
without restrictions. And then the real issue is, he issues a demolition permit, and why was he wrong?
Right.
And there's been no issue raised as to why it's wrong.
Right.
Perhaps you should explore that.
So I immediately contacted all of the city council members and asked that they, I used the wrong language, but basically order a stay until such time that I had an opportunity to file this appeal, because everyone told me that's what I should do. They said that they couldn't do that, and there was no language in the ordinance to have them stop. I was told that if a building is built and it's inappropriate, that often they have to move the building after they've built it, but this is totally different from that situation.
Isn't there a process they can make this historic? And that kind of screws things up for everybody?
So,
There's a process.
Is that process been started?
yes, it has.
And where are we in that? Not we, but you, and them?
You can do it without the owner's approval, but it's not an easy process. I have asked to buy the building, and they are telling me it is not for sale.
Well,
My offer to buy the building started in 2015.
all right. Well, I think I've heard what I need to hear to say that we need to bump this down the road a little bit to let the people that created this problem address it. And I'd like it rescheduled. You know, if you amend your petition, that's fine, to allege a violation of the demolition section. We would entertain that, but right now that's not before the board. We have to take what you file. If you come back quick, so be it. We like Monday meetings. Friday meetings are not favored. And we can meet usually within a week of a request. Dwight, can you contact? We're gonna continue the meeting.
If you continue it,
Dwight, can you contact Weber and ask them not to do anything?
I'm gonna have Mr. Barrett do that.
Can you do that, just so they doesn't look bad? I mean, I see what,
I think that Weber didn't act on this while the appeal was pending, and I think that they could have. I think they recognize the optics. I think this is
will you
certainly-
please reinforce the optics?
Yeah.
Thank you. I vote we adjourn. All in favor? Well, we're gonna continue this, and then we're adjourning. So, Dwight,
Well, the motion was to continue the
I-
meeting out 6 months.
that one passed.
Right.
And then my social statement of a
Passed.
stay, that's 5 to no.
Yeah, you won one for change.
Jesus.
Nice.
And then, so, I don't mean to be rude, but I think we're done.
I'm totally confused, Mr. Toothaker.
Dwight can fill you in what I did.
So far, Dwight has directed me incorrectly, so I'm going to be asking the board for guidance as to where I go now.
Seeking advice of an attorney. I think Jeff spoke of that already.
Any questions from anybody before we adjourn? I vote we adjourn. All in favor? 5 to 1 to 1. All opposed? Thank you.